Now, even if clients don't want to talk about their debt and their liabilities in terms of, well, we don't know how we're going to divide them, we don't know what's going to happen, you at least need to list it on an asset schedule. You at least need to allow for the parties to be able to sign a document that says, we discussed it. We may not know how we want to divide it, we may not know how we want to share it, but this has been discussed, and we'll handle it upon divorce in accordance with state law. If you ignore the situation, then you're going to also be ignoring 50% of our responsibility as an attorney when we're drafting the prenuptial agreements, which is not only to protect their assets and their income, but also to narrow litigation, eliminate litigation, and make it easier for people if they ever do want to get divorced, that they're not fighting at the end of their marriage. So what income will be used for support purposes is certainly something that you're going to need to handle. This goes back in a way to what I was mentioning earlier. Some people will have compensation structures that include bonuses, stocks, stock options, K-1 income, percentage interests in companies, and some states define income very broadly, meaning what income is going to be used for child support, what income is going to be used for alimony, and what may be divided. So you're going to need to not only include any kind of compensation that this particular client may have on the asset schedule, you're also going to make sure that you define what will be included for calculating support. Not every client is going to want to waive alimony, surprisingly. Not every client is going to want to eliminate some sort of support for their ex-spouse. They might feel an obligation to continue to try to support them, depending on their life circumstances. Again, this goes back to really understanding what it is your client wants in the beginning, the initial consult. So if they haven't waived alimony, if they've left alimony open, or in some states they call it maintenance or spousal support, if they leave that as an available option upon divorce, you're going to need to make sure that you define exactly what is going to be used for those calculations. So for instance, you may define in the prenuptial agreement that base income is only going to be used, that bonuses are going to be excluded, stock options are going to be excluded, or something along those lines. It needs to be spelled out very specifically, or you're going to wind up at the end of the day, if the marriage ever does dissolve, you as an attorney might be on the hook for not making that clear in the agreement. You as an attorney might be called as a witness to the divorce to talk about what was discussed and what was understood or what you thought was understood. You might be in a position to have to defend yourself. So that's certainly something you want to avoid. Beyond that, your clients may have to defend themselves in terms of what they understood, what they didn't understand, what they don't want to be included for calculation purposes for support, maintenance, alimony. That's exactly what we're trying to avoid by having the prenuptial agreement. So make it all-encompassing. Don't worry if the prenuptial agreement is 40 or 50 pages long. I know it's a lot of work. I know that clients come in not expecting these agreements to be that long, but they must be. You're protecting them now and in the future. So make sure that you include in the asset schedule, which is attached at the end of the prenuptial agreement for each party, make sure you include exactly how their income is formed. Again, base, bonus, stock options, K-1 income, maybe even a 1099 on the side. Make sure you include all of that. Make sure that you also, as mentioned, provide for, not just in the asset schedule, but how those assets are going to be divided and used for calculation purposes.